I went back in 2023 and got the printouts, and I'm so in public recordings and things. We're gonna get to all that, but I wanted to put the overall picture together real quick for you guys. So I had gotten this, which, as you can see, I mean, y'all know his name, but whatever. That's not versus his name. Okay, so that's everything that was filed in the case. 520, 520, 520. But you recall, if you go back to my other videos, when I first talked to you guys, there was the, in February, when we were sent a petition to establish paternity first, where they, and this has where there should be the docket number. It was during COVID and stuff. None of my papers had that. That's why I got the official copies that had the docket number. And then after that came the administrative order, which was on the 25th. Now, this came before this because it came when the state attorney general introduced themselves, Title IV attorney general, whatever, introduced themselves and shit in that official letter thing. And then this came shortly thereafter. Then came this. Now, administrative order is similar, same thing to a court order to a degree, but a petition to establish paternity, if you filed this, why did you need this? Because based off of this and under law, I should have been able to, like I had told them, we had already told them, we already did DNA testing, he had been paying support, and I'll cite the U.S. handbook from the federal government on child support, which overrides, federal overrides state. U.S. guidelines versus the state guidelines, because that's what in 2023 she had handed me. And the case, so what will they need to know? And this is the stuff that I had told them and had proof of prior, throughout February and March, prior to that test. And the thing that gets me is that needs to know as much information factually about your relationship with him, your pregnancy, the birth of the child. Some of these questions may be personal, but states must keep the information that you give confidential, hence why they had the test. They had the test prior to me sending it to him via email. My caseworker had sent them to him too, she had said, and gave them all the information. They'll want to know whether he ever provided any financial support. He did. Multiple receipts for that. Or in any other way acknowledged through letters or gifts that the child was his. I have a text message where he sends me the results and says, well, I guess he needs to meet his other kids. And like literally the next day, right here is TIS, my son's in Tennessee Early Intervention System. And cover my address there, my son's name, but right there you can see there's his name, list of his parent. And that was January the 27th, because it was held like the day after we got the results back. And then here's his 10 care from March the 16th. That was also prior to them ordering, or right after them ordering the test, but this was all in the process. They finally sent it, and it says here, you've given them permission to sign an application on the applicant's behalf, complete, submit, renewal, blah, blah, blah. For this to be changed, this person had to provide proof that you gave them this permission, meaning he had to be a part of that decision. I couldn't just on my own volition do that. He's also on here on 4 of 19 in another IFSP. There's other legal documents that a father would be on for their child, right? It was just we couldn't go to the health department, and then like I said, the enforcement office was by appointment only. So that right there should have been taken into consideration, and no DNA test would have been needed. We could have just signed the VA like we had asked my caseworker about, and she was supposed to have coordinated, because they coordinate with the enforcement. See, I talked to my caseworker, and then the enforcement contacted with the immediate wanting to gather information. I'm like, yeah, my caseworker should have provided everything, so I repeated everything that I told my caseworker. So that's where we get into this. So petition to establish paternity did get filed into the actual courts, but the administrative order did not. So if you know that's normal or not, let me know. I thought that was a little weird. But here, respondent waives formal service of this petition by his signature on the agreed order, which is filed here within. There was no signature of agreed order. There was nothing. There was a administrative order to take a test because we asked to do a voluntary acknowledgement. We didn't refuse to sign anything. We just asked to do a voluntary acknowledgement, and that's what we got instead. Because in no way, shape, or form does it matter where we got that test, how we took that test. We didn't even have to have a DNA. You do not have to have a DNA test to sign a voluntary acknowledgement. Period. You don't. He could still go sign it today if he wanted. Even with the case closed, he could go sign it. He refused. So this is why I'm having to fight this, because my son deserves justice and the answers and the right thing done. And if he won't do it, I will. Because this would have been filed at a later date because they were closed. I'm almost certain that in February, I know they were. And this is under Tennessee law. It goes straight into a trial, not by jury, just by the judge. And then it is on the father, if he chooses to change his mind, to try to rebuttal or pay for, because the test at that point was not done with the chain of command. He could have ordered a test, but it had to be done in front of the judge, and he would have had to provide enough substantial evidence to make that test seem wrong, because it was perfectly fine for you to pay support on and do all these things this entire time, and all of a sudden it's not. That's how it should be looked at and how it's normally looked at. Administrative order to go test, which is more or less a court order. We have to go take a paternity test. And I didn't realize this. It says you may appeal the administrative order in 15 calendar days, but I didn't really think anything. The only grounds for appealing this order are a mistake of identity, a mistake of fact, or that it was issued in an arbitrary or conspicuous manner. I didn't know what the fuck that meant. But when I looked it up, more or less, the fact that they issued this, even though we had what was called presumptive paternity, and he was in agreement to sign the voluntary acknowledgement. So to order this could cause harm to the family because we were already in agreement. Everything was done. There was no need to go this far and do these things. Because also in the state of Tennessee, when the father is proved to be the father, because if he takes the DNA test, that's pretty much him trying to deny being the father is how they see it. He has to pay $400 for that $20 test. So my belief is, and I've got a consultation with the same attorney I spoke with in 2022. They want $5,000. I know they won't pro bono it, but at least they can maybe get me in the right direction, because this is no longer a motion to set aside. And we're going to get to that, because that's originally what I needed to file. Now I realize it's a whole ass appeals and a lot of more deeper violations, because this was not a mistake.